Okay, here's Richard Lai again. Welcome back to the Rules and Regulations for Financial Advisory Services, Module 5. Now we're at Chapter 2, and in Chapter 2, we are looking at the highlights, the key points of the Financial Advisors Act, the FAA, and the FAR, the subsidiary legislation, which I spoke about earlier in Chapter 1. Now, the Financial Advisors Act came into operation sometime in October 1st, 2002. Right? The purpose of this piece of legislation is to regulate the sale of investment products in Singapore. Now, in the past, there were three separate acts, three separate regulatory regimes governing the provision of financial advisory services in respect of securities, futures, and life policies. In other words, there were three different acts, namely the Securities Industries Act, what they call the SIA, the Futures Trading Act, the FTA, and the Insurance Intermediaries Act. Now, all these three acts have now been repealed, and they have been put together into a single piece of legislation, which is now called the Financial Advisors Act. All right? Now, this Financial Advisors Act provides a consistent set of requirements and regulations for market intermediaries engaging in similar services across investment products. Now, this is what I call the designated investment products under Chapter 1, which I spoke of earlier. All right? So, now, the principles under the FAA and the FAR include the following. First, customers' interest. Now, this is the primary concern of the FAA and the FAR. All right, so customers' interests come first, and financial advisors and financial advisors representatives must have a reasonable basis. You are required to have a reasonable basis for your recommendations to clients, whether prospective clients or existing clients, when you want to recommend the designated products under the FAA to clients. Now, this is to make sure that the financial advisor companies and the financial advisor representatives have given due consideration to the client's interests. So, customers' interest is first. In other words, I think some of you may know, this is what is known as know your client requirement, know your customer's requirement. You must know the financial objectives of the client, the risk tolerance level of the client, the employment status, financial situation, the current investment portfolio, and the number of dependents that a client may have. Now, the second point under the customer's interest principle is in terms of needs analysis. Right? You have to conduct a needs analysis to determine what products that are suitable to a client. And on that basis, you can then recommend a product, a designated product to the client. Now, under the customer interest, you're also required to look at proper documentation. From day one, when the client comes to see you, you must make sure that you have contemporaneous record, right? The contemporaneous record, meaning to say instantaneous record, right? Whatever has been said by the client, you have to have it documented, and the records are properly kept in regard to your recommendation of a certain product to the client. So that is the first principle underlying the FAA and the FAR, that is customers' interest. Now, the second principle underlying the FAA and the FAR, the second principle is consistency. All right, as I've mentioned to you earlier, it consolidated three different acts, and here they want to be very consistent to provide an integrated framework cutting across financial services industries governed by this particular act. Consistency must apply to processes for the same product or similar product, such as single premium investment-linked policies, collective investment schemes, and unit trusts, so that similar rules and standards will apply. That is the second underlying principle. The third underlying principle is accountability. So the FAA is to ensure that the financial advisors and the financial advisors representatives are accountable in a professional and an ethical manner when you deliver products to clients, when you advise clients, or when you sell products to clients. Now, in order to encapsulate this particular accountability principle, there is this provision for a representative acting for only one principle. And we will go a little bit into that later on in this program. In short, each financial advisor representative can only represent one principle. All right. Now, this is to make sure that there is absolute clarity to the investors as to the status of the financial advisor representative. All right. Consumers will understand who will be the person, i.e., the financial advisor representative, or which is the financial advisor corporation that is providing the advice to the customer. This is the principle of accountability. All right. Meaning to say, one representative to act for one principle. Now, the fourth underlying principle is the principle of independence. This is an important principle to protect customer interests in terms of any conflict of interest, for example, between a financial advisor corporation and a life insurer. Right? There could be conflict of interest, or a financial advisor corporation may have some interest in specified products, which they may be recommending to clients. Now, in this regard, there may likely be a conflict of interest. So, therefore, the principle of independence is set up to protect the client, all right, to protect the customers. And there is some restriction to the use of the word independent in this regard. And I will go into that point later in the program. So, to summarize the main key principles underlying the FAA, the key principles are customer's interest, consistency, accountability, and independence. Now, moving to item 4 or paragraph 4 of your text. Now, here we are looking at the need for a financial advisor's license. So if any person wants to be a financial advisor, that person must apply for a license. And look at item 4.2, it is very clear. It says, no person shall hold himself out to be a financial advisor unless he is a licensed financial advisor. That's number 1. All right. If you want to be a financial advisor, you must have a license. Or you are an exempt financial advisor, or a person specified in the first schedule. Right. Generally speaking, a corporation that want to provide financial advisory services or to sell investment products, you need to apply for a license. Now, importantly, I want to draw your attention to 4.6. Now, 4.6 says that the person mentioned above as to who is a financial advisor refers to a corporation and not an individual person. So this is important for you to understand, that a financial advisor must be a corporation. Right? You must have a company, you must have a corporation, it must be a corporation before you apply for a financial advisor's license. Now, item B on 4.7 is worthy of note, and here it says under section 23(1) of the Financial Advisors Act. Now, section 23(1) of the FAA says that these persons below shall be exempted from holding a financial advisor's license to act as a financial advisor in Singapore. Now, A says a bank license under the Banking Act. So if you are a bank licensed under the Banking Act, then there's no need for the bank to apply for a separate license as a financial advisor. It is exempted under Section 23(1) of the FAA. Now, casting your eye down paragraph 4.7, you will see a merchant bank, a company under B, a merchant bank, as a financial institution approved to carry on business under the Monetary Authority of Singapore Act. Now, under C, you got a company or cooperative society license under the Insurance Act. Right? Like, for example, if you're looking at a cooperative society license under the Insurance Act, Income come to mind, right? Income is a cooperative and it sells insurance. So if that be the case, then it is an exempt financial advisor. And D says a holder of a capital markets license. E refers to a finance company. And F, any approved exchange, like SGX, right? Any approved exchange, a recognized market operator, or any approved holding company. Right? It must be an approved holding company in respect of provision of any financial advisory service that is solely, underline the word solely, incidental to its operation of an organized market or to its performance as an approved holding company, as the case may be. Alright, so the status of an exempt company extended to paragraph F in regard to an approved exchange. And of course, there is this open provision under G, where such other persons or classes of persons as may be prescribed. What this means is that MAS can actually include more, can add on more persons who may be considered as an exempt financial advisor. Right? And the representatives working for an exempt financial advisor will be called an exempt financial advisor representative. So that is in relation to 1, a licensed financial advisor, B, an exempt financial advisor. Now the third type at paragraph C 4.8 is what is known as excluded financial advisors. Now this can be found under the first schedule of the FAA. Now, an excluded financial advisor are people who actually provide some financial advisory services in their course of their work, but they do not need to apply for a financial advisor license as such. Neither are they classified as an exempt financial advisor. Reason being that is not the mainstay of their business. Right? It's incidentally they provide advisory services regarding financial products, and the persons under the definition, under the status of an excluded financial advisor are set out at paragraph 4.8. Example, A says any advocate and solicitor, Singapore law practice, etc. In other words, any law firm that is registered under the Legal Professions Act. So if a law firm is governed or registered or licensed under the Legal Professions Act, then you can give advice on some of these financial advisory services or products without having a need to apply for a license. Alright, A2 says any public accountant, again it must be registered under the Accountants Act, and the highlighted word there, incidental to the legal and accounting practice. It is not their mainstay. A lawyer or an accountant, a licensed lawyer or a licensed accountant, it is not the mainstay, not the main business. It is solely incidental to the practice. And that's why they are given the status of an excluded financial advisor. Now similarly, item B, under the Trust Companies Act. Right? The emphasis is still the same. Alright? If you are a company licensed under the Trust Companies Act, and your provision of advisory services, financial advisory services, is incidental to your business, then you are classified as an excluded financial advisor. Now, following down the page at C, it is the same similar argument. a similar reason why the following persons are considered as excluded financial advisor. These include proprietor of a newspaper at paragraph C. Very quickly then, at paragraph D, person who owns, operations or provides information service to an electronic broadcasting or telecommunications medium, and the conditions governing D is set out under subparagraph 1 to 4. And I must draw your attention to the bold letters in the text, solely incidental. Now coming down the page, paragraph E is credit agencies, like your Standard and Poor, like your Fitch, all these credit rating agencies. The purpose is to issue reports and do not contain specific product recommendation. Then credit agencies are also considered as excluded financial advisors. Now, casting your eye down to page F is any public statutory corporation established under any act in Singapore. Now, this means SLAT boards like Housing and Development Board and so on. G, approved trustee under the Securities and Futures Act. The official assignee. This is in a case where a person goes bankrupt and then the assets are vested in the official assignee, and the official assignee then may have to look at the assets and give advice thereto, and as a result of which it does not need a license to give financial advisory services on the designated investment products under the Act, under the FAA. Alright, now similarly, you have the public trustee under the Public Trustees Act, and then you have the liquidator, provisional liquidator, receiver manager, or judicial manager of a company. Alright, so all these people do provide advice regarding assets of a company when a company gets into financial difficulties and is a subject of liquidation or judicial management or under receivership. And more importantly, look at item K. Any foreign company within the meaning of the particular section 4(1) of the Companies Act, whose provision of any financial advisory service is effected under the special arrangement between a foreign company on the one hand and a related corporation on the other, which is licensed under the FAA. That means a financial advisor corporation, a licensed financial advisor corporation, in conjunction with a foreign company, may be considered as a excluded financial advisor. Or any foreign company with under the exempt financial advisor company, let's say a bank, for example, or a finance company. Alright, in which case there's no need for this particular company to apply for a separate license. It is considered as a excluded financial advisor. Okay, I hope that is clear enough in terms of the types of financial advisors under the FAA. I just want to repeat that. First is the financial advisor, which must be a corporation. 2, exempt financial advisor as given by the section 23(1) of the FAA, and finally excluded financial advisors under the first schedule of the FAA. So those are the 3 types of financial advisors in Singapore. Now, coming down to the types of financial advisory services under the Act. Now, this comes under the second schedule, and at paragraph D, it has been set out the different types of products under the Act. Now, A says, advising others either directly or through publications or writings, and whether in electronic, print, or other form, concerning any investment product. I repeat, any investment product other than that set out in the manner in point B below. So that there's a B item there, which we will refer to a bit later, or advising on corporate finance within the meaning of the Securities and Futures Act. Right? So those are the exceptions other than subparagraph 1, subparagraph 2. So if you are advising on corporate finance within the meaning of the Securities and Futures Act, then those product, those advice under corporate finance, they do not come under the products regulated by the FAA. Or under B, as set up, advising others whether by issuing or promulgating research analysis or research reports, whether in electronic, print, or other form concerning any investment product. So in that case, it is incidental. All right, you do not provide recommendation. You are just issuing a report. All right, and then of course the arranging of any contract insurance in red product other than the contract of insurance. All right. Now clearly under E at 4.10, those are the things that you need to be concerned with. In particular, what are the products regulated under the Act, the FAA? The range of products under the ambit of the FAA includes only products that are of an investment nature. Underline that, investment nature. Alright? And section 2.1 says means A, B, C, D. Any capital markets product as defined under the Securities and Futures Act. Now there you cast your eye down the page. So they'll give you the definition there. Capital markets products means any securities, units in a collective investment scheme, derivatives contracts, spot foreign exchange contracts for the purpose of leveraged foreign exchange trading, and of course such other products as MAS may prescribe as capital market products. Alright, so A comes under products regulated by the FAA. Then B, it is spot foreign exchange contract, and then C, life policy, and of course any other products. Now 4.11 is something which came on a bit later after the Act was passed in 2002, and now structured deposits. Look at 4.11. A structured deposit, second line there, has been classified as an investment product with effect from 2nd December 2006. This means that in the past, structured deposits was not a regulated product under the Act. But as time has gone by, then the market or the MAS found that these structured deposits are actually quite sophisticated, okay, and need to be regulated, and therefore they park it under the FAA as well. Okay, so those are the products regulated under the Act. Alright, and 4.9 talk about the financial advisory services regulated under the Act. So there are two things I want you to be careful about. One is the advisory services part. One is the products regulated by the FAA. Okay, they may not be the same, because one is in terms of advices given, and the other is in terms of the products regulated under the Act. Okay. Now F is quite important for you to know. The excluded products, I'm talking about products. So the products are excluded from the definition of investment products are A, general insurance policies, depositing products, and loans and mortgages, right? And the reason are given at paragraph 4.13. Alright, why these three types of products are considered as excluded products, meaning not regulated under the FAA. Now, this does not mean that they are not regulated. They are regulated by some other statutes, some other acts of parliament, right? Not by the FAA itself. Now, that covers the types of financial advisory services and the type of products regulated under the FAA. Now, in terms of the application for the grant of a financial advisor's license, here we are looking at the application, how a company can apply for a financial advisor's license, and what are the minimum financial requirements that are required for the MAS to grant the applicant a financial advisor's license. All right. The details are set out at paragraph 5.3. where it says that in assessing an application, what are the factors that the MAS will take into consideration? And they are set out there from paragraph 5.3a to 3e. Right? They are quite self-explanatory. They include track record and management expertise, financial soundness of the applicant, and its parent company or its major shareholders. It has to be a corporation, cannot be an individual person. B, meeting financial requirements and professional indemnity. Then strength of the internal compliance system. You must have all this in place, the structure, the systems, the processes, and the procedure. You must have business plans and projections. And the number E is key as well, fitness and propriety. That means you must be a fit and proper person, meaning that applicant must be a fit and proper person. The shareholders must be fit and proper person. And of course, as we go through the course, you will find that even the financial advisor representatives, the supervisors, and people related to the provision of financial advisory services or the selling of the designated investment products must be fit and proper persons. Otherwise, MAS will not give you a license at the time of application. Now, there's also a change as at 2010 at paragraph 5.4. In the past, all existing financial advisor's license must be renewed. From 26th of November 2010, there is no longer any necessity for you to renew. And once it has been issued, it will be valid subject to the payment of an annual license fee, unless certain events come about. And these include: 1, where the financial advisor license holder cease to carry on business in any of the regulated activities to which the license relates. Right? The license may be for financial advisory services or to sell the designated investment product. So that's number 1. You stop doing business, well, that's it. The license will lapse. Okay. 2, the license will also lapse due to the winding up of the license holder or other prescribed circumstances by the MAS from time to time. So if the company is being wound up or in the process of judicial management or under receivership, the license will lapse. Or the license is revoked or suspended by the MAS for whatever reason the MAS deems fit, right, to revoke or to suspend a license. All right. Now, generally, the MAS will revoke or suspend a license when the Financial Advisor Corporation has committed some serious offences relating to the Financial Advisors Act or some other act that makes it not a fit and proper person to be licensed to provide financial advisory services or to sell and market the designated investment products. So that is the first part in terms of the factors the MAS will look at whether or not to grant the applicant a financial advisor's license. Right? Now, if you look at A, following down the page, then you can see that they also need a professional indemnity insurance policy. Now, this is quite common for professional services. Like, for example, take a law firm, for example, right? If you are a law firm registered under the Legal Professions Act, you're holding out as a practicing lawyer, you have to buy professional indemnity insurance in case of any negligent suit. Similarly, a doctor, right? A registered doctor practicing medicine is also required to have professional indemnity insurance in case of, again, similar negligent suit by a patient. So here, similarly, you need professional indemnity insurance cover if you want to apply for a financial advisor's license, because a financial advisor is deemed to be a professional activity. Now, there's also a third requirement in terms of the minimum financial requirements. That's under D. I just want to jump that page. Look at D. In terms of the ability of the applicant to meet minimum financial requirements, And if you look at D at page 5.10, casting your line down the page, Regulation 15 of the Financial Advisor Regulations sets out the minimum financial requirements for the grant of a financial advisor's license. If you look at A1, 2, you will see the minimum financial requirements for an applicant which wishes to provide financial advisory services in those products under 1 and 2. And the amount is the paid up capital of the applicant is not less than $300,000. Or where the applicant is a foreign company, its net office funds are not less than $300,000. Right? So apart from the track management expertise and so on, internal compliance systems and business plans and fit and proper criteria. Number 2, professional indemnity insurance. You also need to have $300,000 paid up capital. Alright, so you want to apply for a financial advisor's license to advise on A1 and 2. Now under B, the paid up capital is not less than $150,000. Where the applicant is a foreign company, its net office head office funds are not less than $150,000. And the reason is given there, and this is a serious requirement. And if you look at 510, the last line there, any licensed financial advisor which contravene the above requirement shall be guilty of offense and shall be liable on conviction to a fine not exceeding $50,000. Alright, so the paid up capital requirement is must be there. Alright. Now I'll come back to this later on this. Now back to your 5.8. Alright, so if you want to apply for a financial advisor's license, you must meet certain criteria. Now B at 5.8 gives you some idea as to the grounds where the MAS may refuse to grant you a financial advisor's license. Right? The MAS may refuse to grant the applicant a financial advisor's license. And 5.8a says very clearly the applicant is not a corporation. This is the first hurdle. If an individual person, a natural person, answer no. They will not grant you a license. Right? B, unable to meet or continue to meet minimum financial requirements. That I've alluded to earlier, $300,000 or $150,000, the sum that's been prescribed depending on the type of financial advisory services that the applicant wants to provide. And C, no professional indemnity insurance, and so on coming down the line. Now, DA is pretty important. In fact, I met a case where an applicant from the UK actually made an application for a license here many years back. And this UK company actually was refused because they said accidentally or omitted a particular information, a particular piece of information when they make the application to the MAS. Alright, so it was deemed to be dishonest and so forth. While here DA is quite particular, it's false or misleading. So if you omit to disclose something that can be material, it may be interpreted as misleading, and as a result of which the MAS may refuse to grant you a license. If I understand from that particular case, actually an appeal was made, but then it was turned down as well. So therefore, if you are thinking of making an application for a license, you must make doubly sure that whatever facts that you are putting up in the application form must be true and correct 100%. Alright, if you miss out something or you write something that may be construed as misleading, then chances are that you may not succeed in getting a license. Alright, so again coming down the page there, E, F, G, all the way down to J very quickly. Those are some of the reasons. If you turn the page all the way down to Q, Alright, so those are the many reasons why the MAS can turn down the application for a financial advisor's license. And in particular, I want you to look at Q. The authority, meaning the MAS, is of the opinion that it will be contrary to the public interest to grant you the license. Alright, so the standards set up by the MAS under this particular section of the FAA is quite strict, very strict. Section 9(1) of the FAA. Alright, so if you are really thinking of applying for a license, so take note of paragraph 5.8 A to Q. Now, coming down the page there at paragraph C, you will see the grounds for refusal to grant a financial advisor's license without opportunity to be heard. Now, underline the word without opportunity to be heard. Now, generally speaking, when a person is aggrieved by any matter, that person has a chance to be heard. That person must actually be given a chance to be heard. This is an issue of natural justice. Alright? So, end of the day is, there are certain grounds which MAS will say, hey, look, it is so obvious and so clear that we do not want to waste time, therefore we do not want to give you an opportunity to be heard. We just reject your application straight away. Now, Section 9(4) of the FAA states that MAS may refuse an application on any of the following grounds without giving the applicant an opportunity to be heard. Now, this is quite obvious actually. If you are an applicant, a company, a corporation, and you're in the process of being wound up or dissolved or under judicial management, now obviously, clearly, MAS is not going to give you a license. And if you are going to make an application, automatically MAS is going to reject it without even asking you, without giving you a chance to be heard. Now, B is a similar thing, alright, receivership, whether in Singapore, in respect of any property of the applicant. Alright, so if you own some property and it's a subject of receivership or being wound up or bankruptcy or things like that, grave financial difficulties under those circumstances, then MAS is going to reject it outright. Or a prohibition order. Now, we will come to that later on. A prohibition order is something like a ban, alright? Like if you are a lawyer and you commit a serious offense, the Court of Appeal actually can bar you from practicing the law for, say, a couple of years, 2 years, 3 years, 5 years, or they may even ban you totally, right? Debar you from practicing law. Now, similarly, as a doctor may also be in the same situation, right? If a doctor has committed some serious misdeeds or acts, so the doctor can be suspended for 3 years, 5 years, or totally barred, cannot practice medicine anymore. So, in the same way, a prohibition order is similar to a doctor being barred from practicing medicine or a lawyer being barred from practice for a number of years or permanently, right? So, of course, if an applicant is a subject of a prohibition order, then the applicant is not likely to get a license. And when you do the application, well, MAS say, hey, you're under a prohibition order, right? And therefore, they will reject you outright. And at paragraph 5.9D, again the same thing. If the applicant has been convicted in Singapore, elsewhere, fraud, dishonesty, and so on, in any jurisdiction, and they find that you are not fit and proper in that regard, and they will again, reject your license without giving you an opportunity to be heard. Now, I've touched on D in terms of the minimum financial requirements. I will not belabor that particular point. Alright, so therefore, just to summarize again on this part alone, so you need to satisfy the MAS on several criteria before the MAS will grant you a license. Now, in terms of financial requirements, D1 sets out the requirement for continuing financial requirements. And they look at some very specific things at 511A. and 11B. In terms of the minimum paid up capital that's required under Regulation 16 of the Financial Advisors Regulations. Alright. Now to move on from there very quickly, and we look at paragraph 6. Now paragraph 6, one has to be careful, because if you look at paragraph 6.1, the FAA itself, the Act itself, the FAA also provides for a category of persons to be exempted from holding a financial advisor's license. Now here we are not really referring to an exempt financial advisor that we are talking about. Now you have to pay close attention to this one, because if you look at an exempt financial advisor, it is provided for under the earlier chapters. Alright, when we look at 4.7, if you cross-reference to B 4.7, those are exempt financial advisors and their representatives. Alright, just to repeat, from the bank license under the Banking Act, a merchant bank, etc., all the way down to G at paragraph 4.7. Now these are exempt financial advisors. Now what we are now looking at is exempt persons under the Financial Advisors Act. Now I will go a little bit slow on this one. I just read to you at 6.1. The FAA also provides for a category of persons to be exempted from holding a financial advisor's license. Now this group of persons, called exempt persons, are persons who are referred to under section 4.7F of this chapter. Alright, if you want to refer to 4.7F, you may wish to do so. Alright, there's approved exchange, alright. Now, in the case of an exempt fund manager, here we are looking at an exempt fund manager who is also an exempt financial advisor, meaning a bank, a merchant bank, an approved exchange, and so on. The total number of qualified investors. Now this also will be defined later on. And also accredited investors. These two are not quite the same. Qualified investors and accredited investors, they are not quite the same. Now in the particular case of an exempt fund manager who is also an exempt financial advisor, the total number of qualified investors and accredited investors served should not exceed 30 in total. Now if you fall under this category of being a fund manager who is also an exempt financial advisor, right, say for example a bank or a merchant bank, then if you are advising investors who are qualified investors, defined as qualified investors or accredited investors, and you do not serve more than 30 of them in total, then you are considered as an exempt person under the FAA. Now 6.3 says that of course there are some prerequisites for you to be an exempt person, and at 6.3 it sets out the requirements, the prerequisites, alright, for you to be considered an exempt person, for that category of persons to be considered exempt persons. Alright, importantly is the fit and proper criteria. Alright, you must be able, that group of person must be able to satisfy the MAS, to demonstrate to the MAS that it is honest, integrity, reputation, competence, capability, financial soundness, as stated clearly under the fit and proper criteria guideline of GO1. And this must be on an ongoing basis. It applies to the exempt persons, substantial shareholders, or persons who have decision-making power in the company. So you may have a company being set up as a as a fund manager, all right, or as an arm of exempt financial advisor, and for that group of persons to be considered exempt persons, you must satisfy those criteria. Even the substantial shareholders of that person must also be fit and proper. Right? and then the directors, equivalent persons, and representatives must also be fit and proper. Okay. So you look at paragraph 6.4, 6.5, and 6.6. Those are some of the requirements that must be fulfilled if you are to be classified, if you are to be categorized as an exempt person under the FAA. Now, if you are classified or categorized as an exempt person, you must be aware of 6.7, B 6.7. Any exempt person, including its representatives, cannot represent itself, nor cause to be represented to any person as being licensed, regulated, supervised, or registered by the MAS, whether verbally or in writing. So if you belong to the category of exempt persons under the FAA, you cannot tell your clients or anybody else that you are under the regulation of the MAS, or you are licensed by the MAS, or you are supervised by the MAS. That means you operated free from the FAA, as it were. And as you will realize that these exempt persons are to provide financial advisory services to qualified and accredited investors, to not more than 30. Now, the reason being that qualified investors and accredited investors are deemed to be very knowledgeable. They are deemed to be very savvy in the products that you are marketing or selling to them. And as such, they do not need any financial advisory service from you. They can do their own due diligence, they can do their own thinking as to whether the products are suitable to them or not. So this is a special category of people, usually the very high net worth people. Alright? And these very, very high net worth people are defined as qualified or accredited investors. And even then they limit to the number to 30, not more than 30. So this means actually the MAS, as I've told you earlier in chapter 1, they adopted a balanced regulatory approach. So for certain people that do not really need financial advisory services from the financial advisory companies or the representatives, well, they must come under this category of investors, right? Okay, now let's move on. So then at paragraph C, they give you a very good definition, very detailed definition of who are the accredited and who are the qualified investors. Now 6.8 clearly say an accredited investor, as stated in section 4.1a of the SFA. SFA means Securities and Futures Act. Alright, to refer to an individual, and then they set out to you for you 1 all the way to D. Okay? So, if you are an individual person, for example, let's just take 1A1, your net personal assets must exceed $2 million in value, or its equivalent in Singapore in a foreign currency. So, 2 million Singapore dollars or equivalent in a foreign currency, or such other account as the MAS may prescribe from time to time. Right? So again, you're looking at, if you have more than $2 million, all right, then you may consider yourself as an accredited investor. All right, and then 2 and 3, those are some of the specifications, the definitions where a person may be called an accredited investor. Now, I just want to highlight to you A3, whose income in the preceding 12 months is not less than $300,000 or its equivalent in a foreign currency. So if you are making $300,000 a year, so you may be considered as a accredited investor in the preceding 12 months. Last year you make $300,000, well, you're considered accredited. So that is the definition that the MAS is going by. Now at B itself, on B, you can see that if you are a corporation, if you are a company investing in some of these tax-exempt products, your net assets must exceed 10 million. All right, 10 million in value in Singapore dollars or is equivalent in a foreign currency. And this $10 million must be audited, all right? The most recent audited balance sheet of the company. Or, where the corporation is not required to prepare audited statements, a balance sheet of the company certified by the corporation as the true and fair view of the state of affairs of the corporation as of the date of the balance sheet, which date shall be within the preceding 12 months. So if your corporation, you can still be considered as an accredited investor, but you have to satisfy that financial requirement of $10 million right, in the past, within the preceding 12 months under an audited statement. All right, so that is in terms of the accredited investor. Right. Now, similarly, at paragraph 2 below, you can see there again it refers to the classes of investors in terms of trust under 1A to C. And then under 2, again, it is the definition, the ambit in which an accredited investor may be classified. Right, now then at 6.9, there's a definition there in terms of a qualified investor. Right, they provide a qualified investor in the second schedule of the SFA Securities and Futures Licensing and Conduct of Business Regulations 21A. And then it defines an accredited investor other than 1 and 2, and they give you the definition there. Right? So, as a financial advisor representative, or as you're going to be a financial advisor representative, you pass module 5 and the other knowledge modules, you may need to have a good knowledge of what an accredited investor is and what a qualified investor is. All right? And at the bottom of that page, under 6.9, paragraph 6.9, there's a big point there, note in bold. An exempt person is required to conduct its own due diligence to verify that its clients are of qualified or accredited status. So the onus, the responsibility is on you as an exempt person to conduct your own due diligence to make sure that the clients that you're advising, either individual client or a corporate client, has that status, either a qualified investor or an accredited investor. Now, your due diligence check should be supported by documentary evidence for proper audit trail. Right? In the event that they are suspicious of something or another, and they say, "Hey, have you done your due diligence? Where is your documentation? Where are the documents that show that this particular client ABC or XYZ can be categorized as a qualified investor or an accredited investor?" Then you got to give them evidence. Now, this may refer to income statements, bank statements, and as in a company, then the balance sheet. So that covers that part about exempt persons, which I repeat is different from an exempt financial advisor. All right. So there are some companies out there, all right, that or part of an exempt advisor, exempt financial advisor, that provide services to a very selected, a very privileged, a very private group of customers, right? And as such, you may not need a license to give advice or to market the products, right? And you're called an exempt person in that regard. Now, moving forward, at paragraph 7, there's some restriction as to the use of words, use of terms under the Financial Advisors Act. Now, I've said something about that in regard to the use of the word independent, where there may be a conflict of interest situations, or the clients may felt that, well, there's some favoritism going on when a financial advisor representative represents certain products of some product providers. All right? So the word independent is restricted in its use. Now, similarly, at paragraph 7, the word financial advisor, the term financial advisor, or the term life insurance broker are also restricted. And it says very clearly at the bottom of 7.1 that no person other than a licensed financial advisor, that means you have a license, or an exempt financial advisor, example a bank or a merchant bank or an insurance company, or a person authorized by the MAS shall use the word financial advisor in any language or any word indicating that the person is carrying on business as a financial advisor. Alright, so therefore there is a restriction. You cannot even print the word financial advisor or insurance broker on your letterhead, on your bill, advertisement, and so on. Alright, so there's some restriction to the use as well. And the reason is given below, right? Because these are more or less like what I call protected words. They do not want companies out there to mislead customers by saying that they are a licensed financial advisor. Because if you're a licensed financial advisor, then you are governed by the FAA, FAR, and the notices and the guidelines. Similarly, if you are using the name life insurance broker, it's a similar thing, alright? So it can be misleading if you are not duly licensed by the MAS. And at paragraph 5 at the bottom of that particular paragraph 7, any person who contravenes subsection 1 and 3, that means using the words without the license, shall be guilty of an offence and shall be liable to conviction or fine 12,005, or in the case of a continuing offence, to a further fine of not exceeding $1,250 for every day or part of the day during the offence continues after conviction. Alright, so if a company not licensed or not an exempt financial advisor license use the words like life insurance broker or financial advisor, then you are subject to a fine, okay, of $12,500. Now across the page there at paragraph 8, again they set out the use of the term independent. Alright, and under paragraph 21.1 it states that the circumstances where you can or you cannot use the word independent. Okay, there's a guideline on that as well during the course of this program, as can be found in this book. Now moving forward at paragraph 9, now this is with regard to the RNF. RNF, that means the representative notification framework. Alright, so this is something which is new. It came out in November 2010. You will recall that the Financial Advisors Act came into operation 2002. So after some years, they amended the law, they amended the FAA and the FAR, and also the notices and guidelines, and introduced this representative notification framework, or the RNF. Right. Now very quickly, if you look at 9.2, in the past, before 2010, a representative has to apply for a license himself to engage in activity for which his company, that means his principal, holds a license from the MAS. What this means is that you are representative before 2010, before 26 November 2010. You must apply for a separate license for yourself. Right? Just like a lawyer today, you must apply for a separate license for yourself. Right? But after 26 November 2010, the government or the legislation, they introduced this RNF so that the representatives no longer need to apply for individual license. They do not need to do so. Now the onus is now placed on the principals, meaning the financial advisor corporations, right? The licensed advisor, financial advisor corporations, or the exempt financial advisors themselves, to accept only fit and proper individuals as their representatives. So MAS actually throw the ball back to the companies, right? The banks, the financial advisor corporations. Say, look, you are the persons who are employing these representatives. You make sure that they are fit and proper. Right? They don't have to come to MAS to apply for a license, and we have to verify, certify they are fit and proper. Right? So the onus is now placed on the principals, on the employers, on the financial advisor corporations and the exempt financial advisors to make sure that whoever you appoint as your representatives are fit and proper. Right? And as far as they are concerned, this change brings the regulatory regime in line with some of the other who are exempt by the exempt financial advisors. Normally in a bank, right, or in a merchant bank, you are employed by the bank, so you do not need to apply for a license, a separate license for yourself. Right? So if I'm hired by the bank, so the bank says you are my bank employee, end of story, right? But as far as licensed financial advisors are concerned, they have to make a separate license themselves, insofar as the representatives are concerned. So they want to make it a consistent to be the same as the exempt financial advisors. So in which case now it puts a heavy responsibility, a heavy burden on the principals, on their financial advisor corporations to ensure that these representatives are fit and proper. Right? And under paragraph A there, it shows you very clearly the RNF regime applicable to individuals carrying out financial advisory activities as types of licensed financial advisors, and financial advisors which are exempted by the FAA from having to apply for a license. Now, I just want to emphasize this one: banks, merchant banks, finance companies, insurance companies, insurance brokers under the Insurance Act, etc. All right. So now the RNF applied to across the board to licensed financial advisors as well as exempt financial advisors. Now, 9.6 is important for you to take note. The RNF regime does not apply to entities which are exempt from licensing pursuant to regulations issued under the FAA. That is, we are referring to paragraph 6, 6.1, 6.2, and 6.3 that we have looked at earlier. Alright? So these are the exempt persons that provide advice to accredited and qualified investors to no more than 30 of this special class of investors, as it were, right? That is under 9.6, right? They give you the example there. Example, fund managers who serve no more than 30 qualified investors or financial advisors serve no more than 30. So in other words, this RNF regime does not apply to this group of exempt persons under that particular section of 23B1B of the FAA. Okay, I hope that's quite clear. Now, in regard to the operation of the RNF regime, and under B is a public register. All right. Now, this public register is important because it is available on the MAS website. All right. It is important to have this available to the public. This is in line with the philosophy of the MAS to promote greater transparency within the financial sector. Now, this means that consumers, members of the public, potential investors, prospective customers can take their own initiative. They can go onto the website to verify the status of these representatives whom they are dealing with. Right? For example, if you are a customer, a retail customer in particular, and you are dealing with a particular financial advisor representative, I said Mr. A, you can actually check on Mr. A's status on the website to see whether this Mr. A is on the register. And you also know some of the particulars of this Mr. A on the register. Right? So that you know that this Mr. A is actually registered as a representative of the financial advisor corporations that's giving you the advice, right? Either to invest in one or the other product, other product, other product, other product, other product, other product, other product,